Hey guys, Eric Rodabois. We're going to film a 5 Minute with Eric. So the context here is making sure that you understand what you're signing in a contract. So first, let me tell you a real story. So a client of mine is in the interior decorating business, and they get an unsolicited email from an app developer saying, hey, we want to develop an app for your industry. So our proposal is that we'll team up with you. You guys will be able to contribute your intellectual property, etc. You will pay us, so that's the other weird thing, you will pay us $10,000, and then we will develop this app. We will then sell this app to other people in your industry, and we will split the profits 50-50. So again, just like taking huge big picture, random person solicits, says, hey, give us $10,000, and by the way, sign this contract, and the product we develop, we will then split 50-50. So they come to me and they're like, hold on a second, let us talk to our lawyer, which is the first thing, right? The first thing is they knew better than just signing the contract. So they said, let's talk to our lawyer. They called me up, Eric, and what do you think I said? I said, let me see the contract first. Now, I gotta tell you something, the little hairs on the back of my neck were sticking up because unsolicited request for you to give some stranger $10,000. And let's just pretend that it's a scam, right? The money disappeared, and what are you gonna do? And so, of course, at the very minimum, we wanna do our due diligence. We wanna try to find out what we can about these people, and we need to make sure that the contract that we're gonna sign before we send the money is actually a good contract. So the contract that they sent over was a PDF. Just to be clear, PDF is a document that can't be edited versus a Word doc or some other type of format that can be edited, right? So if somebody shares with me a Word doc, then they're basically saying, here, why don't you make your changes? We can do a red line, we can do a compare. But if they're sending me a PDF, the invitation is not really there for us to change it. Now, I guess we could always print it out and get our pen and we could start writing on it, or we could do other things online. But the point is, at this point, we're in a context that we probably need to make some changes and do some negotiation. Again, remember, a stranger is asking us for $10,000. Okay, so I start reading this agreement, and an old trick I learned a million years ago was to read contracts from the bottom up. And there's a couple interesting points to that. Number one, a lot of the really important stuff is going to be at the end and at the beginning. So I read it from the bottom up, I start with the end, and first thing I see is the choice of law. That's usually one of the ones we put down at the end. Again, this is one of the ones that a layperson might not pay attention to. So what is a choice of law? Choice of law is Colorado. So what that says is that in the event of a fight, we're going to use Colorado law, and then take it one step further, it picked courts in Denver, Colorado, right? That's a jurisdiction clause. They're usually put together. And so right off the bat, I see that if this goes sideways and if my client needs to sue them, we got to get on a plane and we got to go to Denver, Colorado. Now, I could imagine worse places to go. And at the very least, it is the United States, right? So they are speaking English. They are using basically a very similar law to what we have here in Florida. But the point is, that is an inconvenience, right? So let's just pretend it goes completely sideways and my client has to decide, okay, I need to sue someone in Colorado. That means every time there's a hearing, they might have to get on a plane, get a hotel room, right? These are extra costs that they wouldn't need to bear if, for example, the jurisdiction clause was Miami-Dade County, Florida, and Florida law. So this is a point. Now, we raised this as just one of the points. Next, we see there was an attorney's fee clause. We did not see any sort of mediation clause or arbitration clause. These are dispute resolution language we tend to see at the end. Then we got in, remember, I'm reading from the bottom up, we get into the kind of the meat and potatoes about the intellectual property. So the idea was my client's going to give all the knowledge, they're going to put together an app. Who's going to own the app? Who's going to own the intellectual property? Well, the way it was drafted is the app company owns it, which is kind of troublesome, right? Because I'm going to give you all my knowledge and now you're going to own it. And then it was, ready? We're going to split the joint venture 50-50, meaning any proceeds, anything that we earn from selling this app out there in the world, we get to split 50-50. Now, a couple problems. Was it splitting the profits or splitting the revenues? Now, in this case, it said splitting the profits. Well, profit is an accounting number, right? It's not a real number. And what do I mean by that? The real number is the revenue. Revenue is actual money received from clients into a bank account. Profit is that first number minus expenses. Now, what's an expense? Well, I got to tell you, the IRS might have a very different definition of an expense than a very aggressive accountant. And so, for example, when they go out to dinner with their girlfriend and they use the company credit card, is that a business expense? And unfortunately, that is something that will come up. So I always prefer a number different than profit. I don't like to see the word profit because who's going to determine that? Do I get the right to audit your books? How often do I get that right? And so on and so forth. So what I did is I came up with a list of concerns. I said, listen, client, don't sign this until you at least ask them if they're willing to discuss. So they did, and they replied positively. They said, yeah, let's have a call. So they got on a call. So it's a real human being. We're talking on the phone, and they went through all the points. And then they said, listen, would you like us to send you an editable version, a Word version of this contract so that your lawyer can make some proposed changes? And on the one hand, that's really good, right? It shows that they're amenable to making changes, amenable to at least hearing our point of view. They did, however, say that they were not willing to change the Colorado. So my client is going to have to make a business decision, right? The business decision is, should we have a lawsuit in Colorado, or is this something that I'm going to stand firm on and require that we have a fight here in Miami? It's a point to negotiate. It's not a make it or break it point, but it is something to be considering. So guys, there's a lot to consider. So if somebody random asks you to sign a contract, please don't send the money until you talk to your lawyer, and hopefully we revise and we edit the contract into something that'll protect your business.